Good morning, everyone. Happy St. Patrick's Day. We appreciate you all zooming in today for today's webinar on how to perform a Title IX self-audit before the auditors come. We're proud to present Megan Farrell. She'll be presenting on the topic today. And Megan is an advisor and consultant to education clients with a focus on Title IX compliance. Ms. Farrell's background includes working as a Title IX coordinator at Palo Alto Unified School District and Notre Dame of Maryland University. Ms. Farrell recently served as an interim Title IX coordinator for Berkeley Unified School District and currently serves as an interim Title IX coordinator for Los Gatos Saratoga Union High School District. She has also served as an in-house counsel, faculty member, and graduate program director. Aside from these in-house positions, Ms. Farrell also has provided risk and litigation management consulting to institutions, developed internal policies and procedures for education clients, and designed customized training for programs and schools across the country. We're proud to have Megan back for today's presentation. Megan, it's all yours.
Thanks, Ron. Hello, everyone. Great to be here today. I think you got the instructions that questions and answers will go into the question box. So please feel free as I'm going through the presentation to submit your questions. We will take them at the end. And if we don't get to some, we'll even follow up. So it's great to have the opportunity to be here and work with Keenan and Northern California Relief again. I know that those entities do all their best to make sure that their clients and members have access to the most important risk management materials that are available. So, as most of you are dealing with the big challenges around COVID, we thought it would be a great idea to actually address some of the things happening with Title IX. So, in the midst of COVID, we looked at some changes in Title IX, and we're probably under this new administration looking at future changes. So, we're going to jump right in and talk about auditing yourself, taking a look at your Title IX practices, and doing this before auditors come in. So in the past, most institutions were worried about the Office for Civil Rights auditing them. But now what we're seeing is the auditing of Title IX practices is being expanded. And it's not just OCR, and it might be state entities, county entities that you'll have to be looking for coming knocking on your door and trying to find out about your Title IX practices. So today's overview, we're going to talk about performing a self-audit. We're also going to be talking about some specific areas that you want to review. You want to take a look at what is the scope of Title IX, and that scope has actually changed under the new regulations. We're going to talk about community information, how you're getting information out to your communities. And of course, your policies, procedure, and process are very important. Training was something that was highly emphasized in the new regulations that came into effect in August. We'll talk about that. And then we're going to get into just a bit about sort of when the rubber hits the road is like what I say about claims auditing. So taking a look at your files, maybe you haven't had formal complaints come in, but you've had different complaints. Where do those complaints live? If you have had a formal complaint, where are you keeping all that documentation? Is it in one location? If I came in tomorrow and said, show me your claim files, would that cause a panic? I'd be wearing a mask, of course, but the just trying to take a look at, practically speaking, how are you putting all of these things into place? And then some other evaluation techniques to consider and things that I've seen other districts doing around Title IX compliance. So why would we do a self-audit? So first, we want to keep pace with the Title IX regulations that are ever changing. My next slide will talk about that a bit. And then also, the public often comes to request information. And I know that there are a number of districts that recently received a request from an NBC News affiliate in San Jose about what kind of policies and procedures they have, the Title IX coordinator, claims, and things like that. So you really want to be prepared and able to respond as much as you can, taking into account student privacy when someone comes knocking at your door, because that helps you present a very organized Title IX process, office, etc. There are some concerns in specific areas and things that maybe you're hearing in the community. I can say I've worked with a number of districts that have faced a real challenge from their community around their policies and practices. And some have even challenged the ability of a district to put in place the new laws that were in those regulations from August. The scrutiny of similar institutions. So if one district is being looked at, another district will be looked at. If a college is being reviewed and it's in your local area, you can expect that people would be looking at you as well. And then there are some audits, as I mentioned, by some local entities out there. So right now, Santa Clara County in California, through the Board of Supervisors, set aside $1 million to conduct an audit of all colleges, universities, K-12s, and even private schools within the county. They're going to take a look at the Title IX practices. They're going to set up community meetings. So it's a pretty exhaustive um, review. And again, what we often see is one county does something and then somebody else adopts it in another county. So even if you're not in Santa Clara County, it might be something to consider and think about as you're going through your Title IX review this year. So this is just kind of a timeline. You know, where did Title IX come from? How did it start applying to school districts? It's really a law that started in 1972, but we really saw a change in the late 90s. Two Supreme Court decisions that said sexual harassment was covered under Title IX. There were regulations issued by the Office for Civil Rights in 2001, and that set forth a lot of requirements of school districts. And at that time, that kind of became the law of the land and remained in effect until 2011, at which time, under the Obama administration, there were some significant changes. So there was a letter issued. It was called a Dear Colleague letter back in 2011. And then later, 2014, 15, and 16, um, these letters were issued that gave guidance about how OCR would be looking at schools. And at this time, you may have also heard about audits taking place. So if a complaint came to the Office for Civil Rights, they had the right to come and audit all the practices that you had. And as a normal knee jerk reaction, they'd ask for 3 years of your files. So that has not been happening since the DeVos administration had been in office. There were not those kinds of audits, but we don't know honestly what to expect going forward from OCR. So we had all that guidance that was issued, and then the DeVos administration under the DeVos Department of Education under the Trump administration issued a letter in another Dear Colleague letter. It was called the Question and Answers on Campus Sexual Misconduct in 2017. And that significantly changed what was in place under Obama's administration. And it reflected back to those 2001 regulations. So this happens in 2017. And then at that time, there was this promise from the Trump administration that they were going to change Title IX regulations, and they went into this thing called notice and comment period. The important thing to know about that is in 2020, when the new regulations came down, that they had the force and effect of law. So at that time, these changes you had to follow. The changes above the timeline there that came from the Obama administration, they were more like recommendations. Now, you would be foolish to not follow recommendations from the entity that enforces Title IX, but they didn't have the force and effect of law. So right now, what we have is these 2020 new regulations came down with the force and effect of law. We now have a new administration that's already signaled that they're not supportive of these regulations, but they have the force and effect of law. So we've got to still be enforcing these until we get further guidance. And when will we get further guidance? We actually have a little bit of information. I'm so happy that this happened before we had this webinar. There was an executive order issued by the Biden administration on March 8th, and it said, asking the Department of Education to review the Title IX regulations and all agency actions, looking at the specific language, as soon as practical, and think about suspending prior guidance, revisiting prior guidance, rescinding guidance. So the Department of Education has a recommendation to the Biden administration to do just about anything. And this is what I think is great is there's actually a timeline here. So those recommendations have to go to the Biden administration within 100 days. So we're in that sort of 90-day period right now, meaning that by the summer, we should have some idea at least of what's going to happen next. So when I spend a lot of time working with K-12s and also colleges and universities taking a look at their program, their overall Title IX program, what I have found is there are a number of institutions that did not do anything before when 2017 guidance came into effect. they actually didn't do anything right then. So there was a whole host of institutions that just really their guidance goes back to 2016 and prior, and it isn't in accordance with the law as it stands right now. Some of the people made some changes in 2017, but they didn't incorporate all of the new regulations of 2020. So those folks are in a little bit better situation because the 2017 guidance at least gave hints about what these new regulations would look like. But the 2020 guidance is actually somewhat different than the 2017 guidance. So if you haven't changed anything since 2017, that's something else you have to look at. Now, I know all of you are saying, why would I look at it now when we think it might change again? I would say that I understand from the administrator perspective that you might not want to do that. However, you have to remember those 2020 guidelines have the force and effect of law. So, in the event, the unlikely event and unfortunate event, and I'll knock on wood right here, that you might get a claim before we get that new guidance, you're going to make sure, you have to make sure, even if your policies aren't in line, that you're following that 2020 guidance. So let's just get into some of the very basics here. So, first of all, you need to identify who your Title IX coordinator is. This guidance actually goes back to the 2001 guidance. So, since that time, you should have had a Title IX coordinator, designated Title IX coordinator. What I have found in many instances is that person in the past was somebody who had athletics background and they were really looking, the district, the college, the university, was really looking at Title IX enforcement restricted to athletics. And that's not the way you want to look at it. If your Title IX coordinator has an athletics responsibility, that's fine, but you want to make sure that person also understands the sexual harassment rules and regulations around Title IX as well. So you have to make sure that that Title IX coordinator has the necessary authority to carry out their job. And I think if you see some of the press reports regarding Title IX coordinators, you find there are some challenges there, having the resources that they need to effectively put Title IX into effect at the school. Having the authority to speak to someone who has a higher rank than you in, say, a college or university or even a K-12, and have your voice heard as Title IX coordinator about changes that need to take place. Um, you may have seen recently, the most recent thing that came down was a report that came out of Louisiana State, and it talked about the sports program and sort of the sports program having such cachet and importance at the college that a Title IX coordinator coming in and saying you have to suspend an athlete, it might have been ignored. So that is something that you have to take into account, and that's what the regulations say. The person has to have that necessary authority. You have to provide contact information. The title of Title IX coordinator can't be changed. So you don't want to make that Title IX officer, Title IX director. Title IX coordinator is the term of art that in the new regulations you have to have that position filled. You want to say where the office is, the telephone number, and have an email address available. You want to disseminate that information, so you want to send it out to the relevant audiences. And the new regulations talk about employees, students, applicants, union members, collective bargaining agreements, and for K-12s, making sure that information is given to parents. So the way I usually see it in the K-12s, it comes with all of the packet of new information and registration that you receive annually. And if you have a website, it has to be prominently displayed on your website. So that seems simple enough, but I'll tell you, it's actually not that simple. So what I found is under OCR under Obama, they said you need to find the Title IX officer or the Title IX coordinator quickly. So it needs to be 2 clicks. So if I go to your site and I put in Title IX, I should be able to find that coordinator by clicking your search button, clicking something else, and then I got to be there. Schools have different websites, right? So K-12s have a district office website usually, and then the school sites might have their own websites. I know that I've been faulted in the past that we didn't have the information prominently displayed at the school sites, but that it was at the district office. Similarly, in a college or university with multiple campuses or multiple schools, if you have different websites, you want to make sure all that information is available. I know that certain parts of the page, as they design websites, doesn't change. So if you have a link there to Title IX, it runs down the side, it runs on the bottom, it runs across the top. That's a great way to make sure people can access your information. And you want to also maybe engage your community to determine, how user friendly is this website? Are you able to figure out what to do next? And I know that I've heard, we've done lots of outreach to the community, and you often hear back students didn't understand how they could bring a complaint. So, this might be an opportunity for you to engage student groups and talk with them about what would they like to see on that website. How would they like to understand the process of filing a complaint? For instance, a policy that's 17 pages is not something we can expect that students are going to really read through and understand. Can you have a flow chart? Can you have something that is an infographic that shares that information in a different way? So Title IX scope, wanted to just mention this because this was not necessarily clear prior to the 2020 guidance. Students and employees are covered. So anytime we're talking about sexual harassment of employees, by employees, students by employees, students by students, any iteration of that, we're talking about Title IX. So we have the whole sexual harassment piece, and we want to make sure we have the policy and process in place. We also have the athletics piece of Title IX, and we don't want to just disregard this, especially if you're conducting an audit. You want to make sure you're incorporating the athletics portions of this. And in the athletics portion, we're talking about equity and access. So as you can see, the athletic program normally would only involve students, but then you talk about coaches who are employees, and you want to make sure that they have salaries that are comparable, etc. So just a couple things about gender equity and athletics. You want to make sure that your program accommodates the interests and abilities of all your student body. You want to make sure that athletes are treated as valued members of the program, regardless of income generation and or popularity. I can't tell you how many times I've worked with schools and higher ed institutions where it's very clear that this sport gets a lot more attention. This sport, the perception is that it gets more money because it generates more money, and you can't have that kind of disparity. And certainly, often that's a perception issue. And then you have to make sure you're also looking at other sources, right? So, booster clubs or alumni support can often skew how much money a program receives. So, say as an example of this, one place one school district I was working with had a very active booster club and parents who were really supportive of one specific athletic program. And the athletic director was walking around and saw that somebody was working on the baseball field. And he stopped and said, "Hey, what are you doing working on these baseball fields?" And the guy said, "Oh, the athletic director approved me for this." And he said, "Well, I'm the athletic director. I didn't approve this. Tell me what you're doing." A parent had sent somebody to the school, paid the guy, and sent this contractor to the school to improve the baseball field. That is a problem. So this athletic director, to his credit, cut that off immediately. And even the changes that were put in place were changed back because that would have made the baseball team not really in parity with what was being offered for the softball program. So something just to consider. This is just a list of the most often areas where athletic programs get into trouble. I won't run through all of these. Just some of the things to consider. Scheduling is one big issue. Are all of the now sports games offered in the evenings, where a lot of parents and community members can come. Your services that you offer for student athletes. I mentioned here the salary and the quality of the coaches. So these are the areas you might want to just take a look at. You want to review your entire program and make sure that you have a compliant program that looks and certainly on paper is very comparable. And also, you want to take a look at the participation rates in those programs. But you also want to make sure that the tone of the program is that we treat all athletic sports equally. So that's something to take into account. So under sexual harassment, which is kind of the bigger piece and the piece that's been changing so rapidly over these years, if you call it rapid, certainly in the area of law, that's rapid change. This is the legal standard. So educational institutions must respond in a manner that isn't deliberately indifferent when it has actual knowledge of sexual harassment occurring in the institution's education program or activity against a person in the United States. So just, the legal standard here is very high, right? You have to have actual knowledge, and that has been defined in the new regulations as somebody who has authority, learns about a situation either because it's reported to them, they witness it, or they have some rumors about a situation. So if you have that notice, if the person has authority to pass that along, then that will hold the institution liable. For K-12s, they've said that all employees fit into that category of someone with authority. For colleges and universities, there's flexibility around who you're going to designate there. You have to be, this is like the opposite, right? You have to not be deliberately indifferent. So deliberate indifference seems like a huge standard, right? How could anyone prove that we were completely deliberately indifferent? Well, it is hard to prove. And in my work with Title IX coordinators, I will say that I find that they are often trying really hard with limited resources to do the best they can for students. But the truth is that the Title IX matters often get played out in the press. So by the time you get to the litigation and somebody says, well, the institution was not deliberately indifferent, you've been raked through the mud. And so that standard is very high. I will say that there are other places that though you're going to have to be responsive and you want to make sure your program is really kind of top notch to make sure you can respond to those. The other piece of that I will say is that I have been in mediations where they're handled by former judges and we're trying to mediate a case. And on the part of it, the educational institution, we try and argue that, we have this very, very high standard, deliberate indifference, and they just disregard it. Let's just talk about how much money it's going to cost to settle this. So just a couple of things to keep in mind, even though there's this idea that this protection is so huge for educational institutions, but there's so much that happens prior to getting to litigation that you need to take into account. So what are some of the changes? And this is important under the 2020 regulations, the definitions of sexual harassment. Quid pro quo is the idea of, some kind of sexual favor offered and there's some kind of response and you get a favor in exchange for some kind of sexual act. You get a favor, or you don't get fired, you get promoted, you get an A in a class, or you fail a class, that kind of thing. Quid pro quo harassment can only be brought against an educational institution now if there is an employee that's the one that is doing this quid pro quo exchange. The definition of hostile environment changed significantly under the new regulations, limiting that definition significantly. So the definition now is unwelcome conduct based upon a student's sex that is severe, pervasive, and objectively offensive. So it has to be all of these things. It has to be severe, it has to be pervasive and objectively offensive and interfere with the education program. So in the past, some states have had definitions that said it has to be severe or pervasive. So it could be one instance that's very severe. Under these new regulations, that definition of sexual harassment, I can't see an instance where one comment, even kind of the worst comment you could think of, could really rise to the level of severe, pervasive, and objectively offensive. So hostile environment change, and also within the definition of sexual harassment is inclusive of sexual assault, dating, domestic violence, and stalking. So the definitions, the limitations on jurisdiction say that it must occur in an education program or activity in the United States, and the location has to be where the institution has substantial control over both the respondent and the context in which the harassment occurred. So there are some tricky questions here. If you have students traveling around, you have students that aren't on your site that are engaged in educational activities. And even if you say you go away to, go away for a conference or for attending some kind of, group event. Remember when we used to do that, go to group events? You have to really be thinking and analyzing things around how much control do we have? Could we have controlled the situation or could we not have? And it gives an opportunity for an educational institution to say, sorry, this was not something that we had control over. So as you're looking at your policies and procedures, I wish everybody on this call, we have both colleges and universities, and we have K-12s. I wish I could just shout out and say, hey, you need to look at policy 5145.7. So, but I can't because you all have different policies. What you have to look at is some institutions have adopted a Title IX policy. So they call it the Title IX policy. So see what policies you have in place regarding that. any policy that you have around sexual harassment or sexual misconduct, you want to look at those policies and review them. And then because Title IX has been explicitly extended to cover employees, you want to make sure that you're also looking at your employee sexual harassment. You want to make sure that there's a process and procedures for managing sexual harassment. You want to make sure all of them are compliant with the 2020 regulations. Um, However, there are also state law requirements and things you want to take a look at, and policies you have to take a look at to determine, is there a different definition in our state for sexual harassment? The answer in most states, and definitely in California, is yes. How are you going to have those two policies interact? So one of the things that one of the biggest challenges when these regulations came into effect was people were saying, "Oh my gosh, this is a very limited definition of sexual harassment. It will never work in our school environment. We want to follow the state law. We want to be able to look at behavior that is not just rises to that level of hostile environment, but the things that are severe or pervasive." And what has happened is that there's are often parallel procedures or parallel processes going on. So what most institutions do is take a look at the Title IX implications and then either conduct the investigation under both policies or decide that it's a dismissal from Title IX and put it into your state law policy. The grievance practices. This is what under the new regulations. These are the things that need to be in your grievance policy. So as you're looking through those policies that we mentioned, and not only looking at definitions but looking at process, you want to make sure that you explicitly state that evidence will be reviewed objectively, what your standard of evidence is, and the burden of proof. So for many years, most institutions were using preponderance of the evidence, which was a recommendation from the 2011 and 2014 guidance that has been rescinded. In California, a number of institutions are on here, colleges and university. The affirmative consent law says specifically preponderance of the evidence would be used. I feel when working with K-12 districts that it's sufficient to me to say this is the standard that they use at colleges and university. We will use it in our policy as well. So what I see most often is people not rising, getting that level up on the burden of proof to clear and convincing, but keeping it at preponderance of the evidence. Supportive measures are what we used to call interim measures, and that's something you have to make sure you offer to a complainant as soon as you hear that a complainant has a potential complaint. Um, the removal process is when can you get rid of a student, and that is a really tricky and a very controversial part of the 2020 guidance. There are specifics in there, and essentially it follows your crisis management when you would get rid of a student because they were at risk to themselves or to others. You have to offer the formal process, and the complainant has the ability to bring it or not. And the Title IX coordinator can always start an investigation. However, the new guidance, the 2020 guidance, really wants you to follow the wishes of the complainant. So that is somewhat different than what guidance was in place before. Confidentiality. This is probably, I would say the removal process and confidentiality are the most controversial pieces of this. Confidentiality, you can essentially not extend that confidentiality to anybody in this process. You want everyone to keep things private, yes. But if there are parties involved, they are going to get to see all of the evidence that you collect in an investigation, all of the names, everyone. You can't delete things. You can't say to people, I'll keep your name out of it. It's just not in this process. There is complete transparency. Elimination of conflict of interest or bias, that was a big part of the regulations. How are you going to allege those violations? How are you going to make sure that somebody can bring a complaint to say, hey, you know what, I think the person on the hearing panel has a conflict of interest. You want to make sure that process is set forth, because you don't want to wait till the end and have someone appeal, and then you have to go back to this process and look at whether there's been bias or conflict of interest. You want to adopt a reasonable time frame. So the prior regulations always talked about this 60-day timeline. You have some flexibility here, but you want to put those timelines in your policy. Advisors are folks that you need to appoint at the college and university level, certainly for hearing panels. And then Title IX coordinator, decision maker, investigator, you want to see these roles have to be separate and distinct. So somebody conducts an investigation and reaches some decisions about facts. The decision maker then takes that information, makes a decision about policy violation and discipline. And then, of course, there are three required areas to bring appeals. They have to do with if there was something factual that came up later, if there was an error in the process, or if there was some kind of bias or conflict of interest. Any one of those things needs to have impacted the investigation. So that's something to keep in mind and make sure your policies include. Another interesting part of the new regulation said that your informal grievance process has to be really laid forth, right? So what I found at most educational institutions is what they did in the past was somebody comes in with a complaint, they might start moving towards informal resolution right away. They might say, well, let me see if I can reach out to the respondent. We'll start. No, you can't do that. You have to have a formal complaint. You have to make sure that the party that's on the responding end knows exactly what has been alleged. And I would say that needs to be put in writing in your notice of allegations letter. Both parties have to agree, and they have to see a written description of what that process looks like. And you never can use this informal process if your respondent is an employee and the complainant is a student. So, interesting information about training. So, Title IX coordinators and investigators in the past have had to have annual training. The new regulations say that they need to these two roles need to receive training, as well as decision makers and appeal officers, and anybody who's an informal resolution officer. All of those people need to have training before they assume those roles. The regulations don't talk about advisors, but advisors are people that either the complainant or respondent selects themselves, or maybe you as an institution, you need to appoint one for a party prior to a hearing, for example, at the college level. And I put them in here because they are certainly people that need to understand the process, right? If you're going to be an advisor, you need to understand what you're supposed to do. So there's nothing in here that says all employees have to be trained, but I think it's really important to make sure your employees understand what Title IX is, particularly at the K-12 level, because all of those employees can hold the school responsible if they don't respond adequately. And really, for all employees, the adequate response is just send it to the Title IX coordinator so that they can look into it further. The other thing is that your trainings need to be posted, so you need to put them on your website, and not there's no two ways about this. Whatever training you attended, you need to put it on the website. If you've gone to a training from the different entities that are out there, they know of this requirement. They should give you a copy of the slides so that you can post that on your website. So that's something that's required, and it seems to be somewhat guided by this idea that they want to make sure trainings don't have bias or conflict of interest, or sort of are leaning the process towards complainant or respondent in any possible way. So now we get to the trickiness of taking a look at your claim files. So I would say, develop yourself a nice checklist, and depending upon where the claim files exist, in your Title IX office, hopefully, you can go through this. But what I would say is, if it isn't a formal complaint, you might end up with situations where you have to hunt down some of this information. So having worked at a district office, sometimes information about the supportive measures, the academic accommodations we've made, existed at the school site. So all that information has to be in your file. You want to make sure that that's there. So you want to make sure you have, however you learned about the incident, some of that recorded somewhere. When you made outreach to the complainant and offered that formal process, also the supportive measures that you've offered to the complainant. And those supportive measures you have to keep taking a look at through the entire investigation process and thereafter, and you want to keep those records together at all times. I mentioned the offer of the formal process has to be offered so that the person has the decision, the complainant has a decision whether they're going to bring a complaint or not. Notice of allegation goes to the respondent to let them know exactly what they've been accused of. At that point from the process, you should be offering respondent supportive measures as well. I say, if you want to offer them earlier because the respondent already knows about this, then offer them earlier. Absolutely fine. The investigation file, again, information sharing, there's some requirements there. The decision maker process, so the decision maker is that person that's going to make a policy decision. What information is shared to the parties, there's also some steps there. And then outcome letters, and then if there's been an appeal. So what do you want your files to look like? What do they currently look like? How can you improve them? Again, this is where the rubber hits the road, right? Policies and procedures are all great, but if it's not in practice in the files in your office, you could be in trouble. I One of the things I did when I was at a district was people were worried about me coming looking at files, so we put together a checklist, sent it out to the school sites, and said, "You do your own audit first, and then we'll help you if we find out that there's something missing here and it's in my office, or the reverse is true." So, empowering people to take a look at their own files, giving them the tools to do that can be helpful in making sure you just have some transparency in your own internal process. Just a quick word, we're about to wrap up and get to the questions, but just a quick word about state law. A number of the folks on the call, maybe almost all of you, are California residents. And California, for example, has some very important state law that impacts Title IX enforcement. Just want to mention a couple things. First is the Sex Equity and Education Act has a lot of information about what your website should have, making sure that people receive equitable treatment. Um, how to file a Title IX complaint, and what they want to make sure is available is knowing if there's a statute of limitations and what to do. Also, how the complaint will be investigated. You need to have information here about your links to the Department of Education if someone wants to bring a complaint to the Department of Education. And then there's some annual notification requirements. So you want to take a look at those. I just will mention this one more time. Are you looking at, when you have a state process and you have the federal Title IX process, how are you handling these two? Is there a Title IX investigation, then things get dismissed, then you start up your state investigation? Do they happen concurrently? We're investigating everything and everything's just covered in your outcome letter. It's a matter of preference, but you should have a process that you're ready to discuss, ready to put in place if you receive any kind of complaint. Uh, Other policies, remember I mentioned you want to take a look at your employee policies on sexual harassment. I will say that that's something that people haven't done before. These new regulations regularly haven't always looked at this. But your process, your sexual harassment process for your employees has to at least touch on the Title IX definitions. And then again, can move to your state law process. You want to look at non-discrimination policies, because a lot of times non-discrimination policies will mention sex, gender, things that fit under Title IX. And you want to make sure that there's some clarity about, where does this process take me? Because the Title IX process, unique to Title IX only. If somebody steals a bike on your campus, they're not going through this process. They're not going through this, and what I'll say, quite honestly, onerous process. So just something to keep in mind. Disability services, you just want to have some consistency with regard to, we offer the Department of Education the website link if you want to bring a Title IX complaint. Our notice of non-discrimination is inclusive of some of this the non-discrimination policy and information about disability services. And then some other things to just take into account. I mentioned the Santa Clara audit. One of the things that the Santa Clara audit is doing is reaching out to the communities. So they're going to audit, they're going to take a look at all your paperwork, digital paperwork at this point. But they're also going to look at what your community has to say. So how are some ways that you can engage your community? You can send out surveys. You can have focus group sessions. You can get together. There's a lot of active survivor groups on campuses. There's even some very active, more respondent leaning groups on campus. How can you bring them to the table and figure out what are the challenges and where are the gaps? How could we have address barriers that people might face in reporting their experiences? Is there a reason why a certain student is not bringing a complaint or not knocking on the door of the Title IX office while other students are? And then provide a safe place for individuals to provide feedback on the Title IX process. So I always say, if you go through the Title IX process and you're unhappy, then you probably went through a good Title IX process. Regardless of which party goes through it, regardless of the outcome, parties generally are not happy at the end of it. But the truth is, that shouldn't mean we just allow that to continue, right? We want to make sure at least we're serving the needs of our communities as best we can. And sometimes you really have to sit down and speak with them to get that additional information. So I know that you all have a lot on your plate, and this is not something you want to take on maybe today, But I will say that it is something that you should think about for the future. And you can do it in small doses. It doesn't have to be 100% of the community. You can take the activist members, just make them part of the process. I have found that that can be really helpful going forward. And I'll just give you one example of this. I worked with a K-12 district, and the students wanted to talk about the Title IX process. They put together this beautiful infographic. And what I discovered in this process was the only thing the students cared about was, where on this timeline do you call my parents? That was the only thing they cared about. They didn't care what happened afterwards. They didn't care. They wanted to know how far they could get before the parents had to be involved. And that was really telling for me, because that's not the way I was thinking about the Title IX process. And it was what was most important to the students. So with that, I think we're going to move to your questions right now, and I will introduce the woman who needs no introduction, Kathy Espinoza. And if you've been on a Keenan webinar, I understand you know all of her background, and I don't need to review that for you. Kathy, are you ready?
I am ready. First of all, I want to do the disclaimer because that's what legal has us do. So Keenan and Associates is an insurance brokerage and consulting firm. We are not a law firm or an accounting firm. We don't give legal advice or tax advice, and neither this presentation, the answers provided during the Q&A, or documents accompanying this presentation constitutes or should be construed as legal or tax advice. You are advised to follow up with your own legal counsel and or tax advisor to discuss how this information affects you. So with that, let me get straight to the questions that we do have. First one, what are some examples in regards to the Title IX website? What are some examples of notifications that need to be displayed on these websites?
So your website, and I will say, if you're a California institution, the Sex Equity Act that I mentioned here in the last couple slides sets forth exactly what needs to be on your website. And it is broader than what the Title IX requirements are. So the Title IX requirements are very much about, where's the Title IX coordinator? How can I get in touch? And how, if I don't believe the Title IX coordinator will do the right thing, how do I get in touch with the Department of Education? That's kind of the underpinnings of everything around Title IX. Who's your coordinator? How do I contact them? And then the second piece of, how do I get in touch with the Department of Education? For the state, though, there are a lot of requirements. They want you to outline specifics about your policies and procedures, links to your policies and procedures, all sorts of disclaimers and things like that. So I would invite if the caller's in California, to take a look at that Sex Equity Act. At a bare minimum, you want to make sure that your Title IX coordinator can be found very easily, and make sure that there's contact information, and that information is out to the public. I would say that I would enlist HR and student services to say, we need notifications to be available to applicants, to employees and collective bargaining agreements from the HR side, and to all students and parents for K-12s, about what our process looks like. So, I know in my school district where my children attend, I get, and literally I'm doing this because they send it in paper, stack of paper in there. There's a Title IX, there's a sign off document that you have to say you've seen the Title IX process and you know how to use it. Now I'm very in touch with Title IX, so I pay a lot of attention to that. I'm not sure if parents actually look at that. I'm sure students don't look at that until they need it. So make sure your website, if you have one, and I imagine most people do, 99% of us do, that it's easily searchable to get to that person.
Excellent, thank you. Another question, do the Title IX requirements apply to both public and charter and religious, et cetera, et cetera?
Well, that's an interesting question. So the Title IX regulations, the link that pulls people in is federal funding. So if you don't receive any federal funding, essentially you're immune from Title IX. However, I will say, I've heard from private schools, and I've heard from a group of private schools around this, and they have said that they accepted federal money for PPE during COVID. And by accepting that federal money, they were advised by their outside counsel that they were now subject to Title IX. So there's the kind of big question. And then some of the private schools think that those loans will be forgiven, and then they can go back to not enforcing Title IX. Well, I will say this. The most challenging and the most heartbreaking part of Title IX work is when the public is outraged at you, and that you're not going to be immune from that. You might be immune from the lawsuit in relation to Title IX, but you can still be sued for breach of contract. You can still be sued for not having a safe environment for students. So I would be, if I were in a private school, I would look very hard at this. I'd get outside counsel to tell you whether you've accepted any federal money, and then I would make sure that we have practices in place that they don't have to mirror what Title IX says, unless you're subject to Title IX, but they should in some ways be consistent, offering people the opportunity to bring a complaint, making sure that matters of sexual harassment, and God forbid sexual assault, get to the people so they can address those problems.
Perfect. Thank you. What about the COEs? Are the policies that are required any different than those that are required for K-12 and other campuses?
Um, the I don't know what does that acronym COEs mean?
County Office of Ed.
Oh, okay. Um, so most I would say most counties will have taken a look at what changes took place in Title IX. I know, for instance, Alameda County in California, they were looking at what changes were in place, and they provided recommendations for all the educational institutions within their district that reflected those. So I would say California School Board Association did the same thing. I would say that the recommendations from there should it be inclusive of this, but I wouldn't just rest on my laurels and say I did everything the county told me to do. Because the county is, we got the federal government, we got state law, we got county down here. I want to make sure that you've gotten all those tiers covered. So I would take a look regardless. But most counties, and I think California probably is, it's just so much better equipped for this. They really do provide resources at the county level, at the state level that help. But you just want to make sure your program is completely comprehensive. So I wouldn't just say, "Oh yeah, I did everything the county said." I would take a harder look at the whole process.
Excellent. When you were talking about the legal standard for response, you said that K-12, all employees have the authority to pass the rumors on. Is there a difference in hearsay and rumors versus seeing harassment with your own eyes?
Well, this is what I would say. The I think that for all employees, actual notice. If you witness something, you have actual notice. If you've heard one rumor about a situation, maybe that wouldn't rise to the level of actual notice for any employee. But why not pass the information on to your Title IX coordinator and let them do the follow up? So I think rumor, innuendo, pass that information on to your Title IX coordinator. You want to keep track of that because Lord knows I've been in too many investigations where turns out there were 15 rumors about this staff member, faculty member. People never reported because they didn't see it with their own eyes. They didn't, oh, it looked creepy, or we didn't like the way this person was acting, or students said that they felt uncomfortable, but I didn't really have the information. Pass it along. Pass on that information. Let the Title IX coordinator at least be keeping track of that because you know what they say, when there's smoke, there's fire, right? So sometimes we just get the smoke, but we're keeping track of the smoke, right? So this year we had this problem. This year we have this problem. Maybe we have a problem with either the student or the staff member and we have to address it.
Perfect. Thank you. Um, what if an employee comes to you with allegations of sexual harassment that does not qualify as severe, pervasive, and offensive? What do you do when no formal complaint is filed?
Okay, so I'm going to start with one thing. I had a phone call last night that has triggered this to me. Unless you're in human resources, you shouldn't be doing that analysis or you're the timeline coordinator, right? So it's not up to you as a staff member to decide whether it's severe or pervasive. Don't get involved in that. Your job is to pass along that information. Um, so if you have, regardless, students, employees, doesn't matter, and it hasn't risen to the level of Title IX, then what most school districts, what most colleges and universities throughout the United States are doing is saying, we're now an offshoot here into our state law process, and you go through the state law process where the definition is not as onerous. Kathy, I would just say I hope it felt like a little bit of a two-part question. So if that person who submitted it has a follow-up, please let me know.
Okay, I will. You talked about documenting and posting training on their Title IX websites. And I know I get a lot of questions about is the Keenan Safe Schools and the Keenan Safe Colleges trainings compliant? And the hardest part for me is letting people know that this is not a one and done type of training. That, like you mentioned, that appeal officers, investigators, decision makers need special training, and that's separate from the Keenan Safe schools, Keenan Safe colleges. Would you agree?
I would, and I think that what's important, whether you use the Keenan Safe Schools, Safe Colleges, or if you use an external entity, is to ask that question right up front. Is this going to be compliant with what I need to do from Title IX? Am I going to get a copy of those slides? So you know that going in. And that you want to make sure that the topics are covered that need to be covered. And then you will get a copy of that training. That's just kind of like the way things work right now for most entities. But the question is really upfront: is this compliant? And I think if I'm not if I'm not incorrect, I think that safe colleges and safe schools include disclaimers about whether that does or does not cover that. So just make sure from the get-go that you know what you're getting. Because I mean, and I agree with you, Kathy, it's not a one and done situation. You need to train people more often than once a year, in my opinion, to make sure that they stay on top of this. And people who have specific Title IX roles, like a coordinator, an investigator, or a decision maker, appeal officer, you want to make sure that they get training as often as you can fit it into your schedule and budget.
Good, I agree. Our programs are more of a Title IX overview and the training for all employees so they know what to do. But the specific ones for the decision makers and investigators, those require different trainings. Um, Another question: most K 12 investigations take place at school sites. So, what is your advice about how to audit those file or claim files?
We're coming over tomorrow. We're going to be looking at all your files. And I said it kind of like tongue in cheek, but the truth is, what I have found, and I wish I had. Look, I have an example here. When I work with K-12 administrators, I say, can you tell me what happened in this investigation? They pull out their moleskin, and they've got everything that happened every day in here. So what they have is, I interviewed 3 students. That's in the middle of, I responded to a fire drill. And, so there's a ton of stuff in there. I always say, keep it in there. That's your way of doing it. Photocopy it and send it to me. So you have to I would say to the schools, we're going to take a look at what files you've been keeping, because we have to keep them centralized too. And there's a lot of confidential information in Title IX matters. That's another reason you want to keep it centralized. You don't want that sitting in, say, I've been in administrative offices that students walk through, here and there, and they're picking up snacks out of this office and they're doing other things. You really want to make sure that these files are very secure. We've always kept ours in a locked file cabinet in a locked office. So I would say here we're coming, and this is a thing. I've gone to a lot of districts that are in crisis, and I think as Title IX workers or people that are coming from the office, you always want to be a facilitator and not a disciplinarian. We're not coming over to get you in trouble. We're coming over to make sure our files are good and in good shape, and we'll help you. So you don't have that? Okay, let's take a look at your other thing. Do you have it? You don't have it? Okay, let's make sure in the future we always keep a copy of that interview statement that we received, or student statement that we received. You think you lost it somewhere? Okay, how can we deal with that situation? We can't solve everything, but it helps people understand what are the expectations. And I find that most school site administrators are worried because they don't know what the expectations are.
Excellent. We've got time for about one more question, and it's a scenario based question for you.
Okay.
Is Title IX based on equity, which are programs getting what they need, or equality, boys and girls programs getting the same? For example, baseball and softball coaches are asked what they need for their program. Baseball asks for $6,000 and softball asks for 4. Both are fully funded, but softball finds out baseball got an extra $2,000 more, and they want their $2,000 extra, and they claim Title IX. What advice do you give them? Do we give them the additional 2,000? How does that work out?
I will say that's an interestingly phrased question. But with regard to athletics, honestly, what they're going to look at the end of the day is the budgets, right? So if what has been requested here is, and what has been requested here, that's not going to be something to hang your hat on, right? Oh, well, they never asked us for more money, so that's why we gave more money here. I say it is definitely um it is parity, maybe not equality. Parity. This program gets $5,000 a year. This program gets $5,000 a year. And if you can explain, say, gosh, I know between football and softball, there's sometimes the fields are different, whether they're turf or grass. If you can objectively explain, they need more money here because it's a grass field for maintenance. That's an explainable thing, not just that. Well, they asked for more money, so they got more money, but you didn't ask for more money. I think that's going to get you in trouble.
All right, perfect. Well, that's about all we have time for. And I would like to say thank you so much, Megan, for taking your time to help educate us all on Title IX. And I want to say thank you to everyone for attending this morning.
Thank you, Kathy. Good luck to everyone.